number 13-33479. We're here on plaintiff's verified emergency motion to enjoin the referendum special election ballot question, to enjoin counting ballots, and to enjoin certifying the ballot results. Also, I received today a motion from Grove Bay Inventor Group LLC, emergency motion to intervene. So let me have everyone please state your appearance, and then I'm going to hear the motion to intervene first. That's been filed by Grove Bay Inventor.
Good afternoon, Your Honor. I'm Linda Carroll. I represent the plaintiff, and the plaintiff is sitting next to me at council table, Ms. Lovers. Thank you.
Good morning, Your Honor. Warren Bittner, Deputy Emeritus, on behalf of the City of Miami, and with me is Veronica Hikes, Assistant City Attorney.
Good morning, Your Honor. Warren Rosenthal, Assistant County Attorney. I'm with Michael Valdez, also of the office who represents Penelope Townsley, the Supervisor of Elections.
Let me say good afternoon. I'll take it back to my own. You say good morning.
Oh, I'm sorry, bro.
No, that's all right. Just to let you know I'm listening.
Good afternoon, Your Honor. Juan Carlos J.C. Planas. I'm here along with Richard Perez, and we represent Grove Bay Investors, LLC.
Planas, let me hear from you first as it relates to your motion to intervene on behalf of your client.
Yes, Your Honor.
I read your motion, by the way.
Okay, Your Honor. Basically, we have a lease with the city. Therefore, we have a vested right. We are the named lessee that is in the ballot measure that Ms. Solares is attempting to kick off. Based on the case law which you saw in our motion, we have a right to intervene as an indispensable party, but even as very least, because these pleadings have just begun, as a mere intervening party as well, we have a right to be heard, and therefore we believe that the law requires you to grant our motion to intervene.
Ms. Carroll, you wish to respond?
I would like to respond, Your Honor, only to make a couple of corrections. My understanding of the approval by the City Commission was that there is no contractual right, since there is no lease, until after the ballot election takes place and there is approval by the voters. I think that's number one. So I disagree that they are the lessees. Number two, I haven't seen their motion, but I would say that I don't believe they are, even as a lessee, an indispensable party under the recent decision by the 3rd District from the City of Miami Beach's case that I believe council is familiar with, because it specifically says with regard to a ballot election, even somebody who would be a potential contractor or a contractor is not an indispensable party. They may be a necessary party, but they are not indispensable. Having said all of that, I do not object to their intervention, but only as a necessary party, but not as an indispensable party.
The city,
The city believes that they are an indispensable party. I think these...
so you join in on that?
Yes.
Thank you. The county like to be heard.
Whether necessary or indispensable, we have no objection to their intervention.
Thank you. The motion is granted. All right, now let's take up the motion filed by the plaintiff to enjoin. So Ms. Carroll, let me hear from you first, then I'll hear from the city. I'll then hear from Council Mr. Planas on behalf of Grove Bay, and then I'll hear from the county.
Your Honor, actually, if we may, I think the city joins in as we prefer if the county spoke first. Because of the nature of this type of injunction, we believe that the needs of Supervisor Townsley are the most important.
Is that an agreement among the parties?
That's fine. I'm okay with that.
It's news to me, but if they want me to speak first, I'm happy to talk to my attorney. That's what we do.
They have faith and trust in the county, as
Well,
they do in the American dollar.
that's two. But I just want to make sure the court has gotten a copy of our opposition. We filed it e-courtesy last night, and I
I
filed
did
it.
not receive it.
Okay. Would you mind if I first? Yes, I
I'll
did.
take it. I'll peruse it as I'm listening to you folks. All right, so let me hear from Ms. Carroll, and if the city and Mr. Planas wish to refer to the county, then I'll hear from the county first, and then from the city, and then Mr. Planas. All right?
Would it be acceptable, Your Honor, if I address the county's issue first of all, because it's compartmentalized, since the county states that they're not taking a position on the merits, and I would like to just address the merits separately from the first part.
You can take it out as you wish. Be mindful, I report you all 30 minutes today.
I understand that, Your Honor.
I fitted you into a very crowded calendar that I have today. I have other matters that I need to get to, and I'm done with this. It actually starts at 3 o'clock. If I'm not finished, then I may have to recall you following my completion of other matters this afternoon.
Thank you, and I do appreciate you fitting this in, Your Honor. Before I begin, Your Honor, I'd like to, since I only received the county's motion late last night when I got back to my office, and the response, I'd like to give you a copy of a supplemental affidavit with supporting exhibits, and it addresses the issues pertaining to the timeliness issue. I've already given counsel a copy. Yes, Your Honor. I will be brief in summarizing the supplemental affidavit because it goes directly to and demonstrates that the county's motion and argument is based on wrong facts. For example, when they state that Ms. Lars delayed after the city approved the final language on July 25th, 2013, you'll see in Exhibit 10 that the initial proposed resolution that was presented to the City Commission during the meeting on July the 25th, we provided to the court, and the language in that resolution does not match the final language ultimately approved. Just by way of one simple example, in the heading of that resolution, it makes reference to $1.8 million. That's erroneous. More importantly, Exhibit 11 that's attached, is a copy of a public records request that Ms. Solaris sent to the city on August the 5th, 2013, specifically asking for the actual language approved by the commission, which was to go to the voters with regard to the Grove Harbor project. Immediately above that, you will see there is a response from the city attorney's office stating that they were going to try to find that. And then above that, there's a further entry stating that Veronica revised the following. We may change before the September 12th meeting, but this is what we have approved for now. And now there's additional language. Now, in addition to that, so that as of August the 5th, the city attorney's office is saying we still haven't finalized the language. You will also see on Exhibit 12, this is a memorandum from Julie Drew. She was the city attorney at the time. It's dated September the 6th, 2013, and it states that they are she is attaching and sending to the city clerk, Todd Hannon, the actual final language for the referendum. And attached to that memorandum is the actual resolution R-130304, 05. You'll notice also, Your Honor, that on the very bottom of it, on the bottom right-hand side, it will say File ID 13-800836 version, version, :3, close parentheses, printed on 9/6/2013, which is the same date of Ms. Brew's memorandum. And in fact, it was based on, and these documents here we obtained from the website, including the memorandum from the city attorney, and it is the third version that is in fact Exhibit 5 to the emergency motion. Now, in Ms. Solaris' affidavit, it goes on to state that she doesn't recall exactly when she first saw the final language, but she knows it was no later than October the 20th, 2013, and that's going to be Exhibit, and I'm relying on Exhibit 13, because this is a copy of the page, I think it's 6B from the Miami Herald that was received in her home, dated October the 20th, 2013, and this gives the ballot language. Therefore, the best she can piece together in this short period of time was she only had, at least she had the official language as of October the 20th. We're not sure how much before or after. Excuse me, how much before, but clearly we had it after. The entire argument that, in terms of untimeliness, is not only predicated on faulty facts, but it's also predicated on faulty law. The two cases that are cited by the county are not cases involving injunctions. One of the ones pertains to, that I can think of quickly, is an attempt by someone to have declared illegal a primary election. They made the application under a writ of quo warranto, not for an injunction, because the election had actually taken place. I think this is the Wheeler case, if memory serves me correctly. And in that Wheeler case, the candidate in a primary lost. And just before the general election, in order to slow down the general election, if you wish, he filed this writ seeking for the court to declare invalid an election that had already taken place 4 months before, on the grounds that the voters, or a large number of voters, hadn't paid poll taxes. Now, I know we don't have poll taxes any longer, but the point of the matter is, we're not here seeking to invalidate an election that has taken place. We're trying to prevent the miscarriage from happening. And in fact, one of the major concerns here is, as I mentioned with regard to Mr. Planis's client status, according to the resolution that was passed, the relationship is not a contractual relationship until after the voters go to the polls,
I understand.
and therefore we have an urgency
Ms.
because we're going
Carroll,
to have.
you made that point earlier. Let's address whether or not you can establish the necessary elements for the imposition of an injunction that you're seeking here today. Let's please address that based on the belief that you're impressing on this court. Let me hear your argument as to those issues.
The argument, Your Honor, number one, clearly Ms. Lawrence has standing because she is an elector of the city. She will be injured, as will all of the voters, if there is an election that's allowed to proceed and the procedures and the requirements for the election are not fully complied with. The Florida Constitution, Article 1, Section 1, specifically reserves to the citizens the right of all, as to all powers, including the right for constitutional amendments, as well as amendments to charters. So they have that right. The charter existed says you cannot do certain things with regard to city lands, you cannot specifically, or more specifically, do things with waterfront land. Now they want to change this, and they, in order to go forward with it, they have to be able to present to the voters an explanation in the ballot summary. They have to provide a title that explains to the voters clearly that what they are, the purpose of what they're seeking to accomplish. They have not done so, and if this court allows a ballot such as this to go forward, and as I said, I wanted to try to reserve on addressing the more specifics that are raised by the city. If you wish, I will go through those at this time, but my preference would be to address the timeliness issue because that clearly is not a valid argument.
Well, you addressed it, and I want to get to the heart of the other issues. I don't wish to bifurcate anything.
All right, Your Honor, then I shall.
I specifically set your motion to enjoin, and that's what I'm here to address.
Your Honor, according to the city's memorandum in opposition, they claim that the ballot, as written, is proper. In their opposition, they ignore existing Florida Supreme Court case law that states that if you're going to seek to amend, or if you're going to present some type of public measure before the voters, that the voters have to be given information, sufficient information for them to understand the effect of what they're doing. Now, in the case of Askew versus Firestone, which is cited in the memorandum that we filed on the motion. The Florida Supreme Court held that a provision to amend the Florida Constitution that would require former legislatures to file disclosure statements, they struck that down because there was no explanation, there's no acknowledgement, no provision of the fact that there already was a constitutional provision that banned the legislatures from any type of lobbying activity. And the court found that the non-disclosure, I believe it was in that case where the court first coined the phrase, hiding the ball. If they didn't acknowledge or explain to the voters in some form or fashion in the ballot summary, there is this existing prohibition, but they wanted to change it to make it a lesser standard. The same thing true in the Armstrong v. Harris case, also cited in the memorandum or motion. And in that particular case, there was a constitutional provision that on its face would sound very good. It would prohibit cruel and unusual punishment. Except for the fact that the Florida Supreme Court struck that down because we already had a constitutional provision that said and banned or prohibited cruel or unusual. But there, nowhere in the ballot summary was there any information being provided to the electorate that they were changing just one little word from the conjunctive to the disjunctive. And they found that that was not providing adequate information in order for the voters to intelligently comprehend the effect of the ballot question. Similarly, in Florida Department of State versus the Florida State Conference of the NAACP, the Florida Supreme Court struck down a proposed constitutional amendment that would set standards to establish legislative and congressional district boundaries. And the reason they did so was the fact that they were already certain standards, and what was being proposed in this more recent constitutional proposed amendment was going to lessen the standards. Again, if there is some type of standard established or some prohibition established, if you're trying to lessen or weaken the strength of what already exists, that has to be disclosed. The next case I would cite to the court is, in fact, the case that is relied upon by the county. And it's reported at 592 7 2nd 225. It's the advisory opinion to the Attorney General, limited political terms in certain effective offices. Now, in that particular one, the court did not strike down the ballot question for a very simple reason. In this particular measure, there was a proposed constitutional amendment that would establish term limits. And the challenge to that proposal was, well, you didn't say or didn't tell the voters that there were no term limits when you're trying to impose term limits. And the Florida Supreme Court rejected that out of hand. In fact, I believe the court stated, the Supreme Court, let me get the exact language. We do not find the failure to indicate the lack of term limits to be misleading. This is not a situation in which a ballot summary conceals a conflict with an existing provision. There is no existing constitutional provision imposing a different limitation. And therefore, the crux of the matter, and what I attempted to put forth in the emergency motion was, we already have 3F III that sets exact standards for leasing of waterfront property. It states, in fact, no lease will be valid unless all of the above conditions are complied with. They give a window, if you wish, in order to get a valid lease, but in this case, they haven't even relied on or sought approval from the voters under 3F. They've totally ignored 3F. As I indicated in the motion, when you take a look at the actual resolution that was ultimately approved with the ballot language on September the 6th, That language states that the referendum is being ordered pursuant to 29B of the charter. 29B does not apply to waterfront land generally. Well, generally it does, but the more specific provision is 3F. Their own resolution calling for this does not call for approval under 3F. They are hiding the ball again here. In addition to that, Your Honor, you'll notice in our motion that, in fact, one of the reasons for my delay in getting it out was I had requested, made a public request seeking to find out why in the resolution that was approved in September, there was a reference to a city code, I think it was 2-12. I couldn't find that anyplace. And then, I think it was the day before we finally, I was able to get the motion filed, we get a memorandum or an email response, and I attached it to my motion, in which they advised that there was another scrivener's error, and this time, the scrivener's error is that the city's ordinance that they were citing to should have been 2-112. Well, that provision, and it's attached to the motion, and I believe it's Exhibit 8, that says that the city commission shall request, I believe, proposed charter amendment, because it all pertains to a charter amendment. So in reality, what is happening here, under the guise of 29B, first of all, it's being presented as if this is just trying to get voter approval for this lease. In reality, if you plug in the fact that it's section 2-112, they are attempting a charter amendment. At least, if you go by the references, nowhere is there language in this ballot, even the one that was prepared on September the 6th, is there any statement we're trying to amend any charter provision? And clearly, are they attempting to amend section 29B pertaining to waterfront land, when 29B is not the appropriate section dealing with waterfront land? We have, it seems to be repetitive hiding of the ball, so to speak here. There is, it's gamesmanship. I think, in fact, I used the word speak with in my motion, because what is being done is certain words are being thrown out. They talk about submerged lands and city-owned waterfront and submerged lands. I believe it's in the title. Well, the resolution that approved the proposed lease doesn't talk on the caption about leasing submerged lands. I believe, in fact, the submerged lands that they're talking about is really where they're going to be building structures. So they create or depict, essentially, I don't know, I guess it would be some type of barren land in the middle of, or someplace in Coconut Grove. They don't say where, and I'm not suggesting that they have to give a long-winded address, but there has to be a better description in the caption if they're going to refer to. They can't just simply suggest to the voter that this is just barren land. I mean, it would have been a great idea to say we're advertising, we're selling submerged land if it was the 1920s, as opposed to what happened, but it's not appropriate for a submission to the voters today when everybody knows that this land is not just simply submerged land, this is not just non-income producing land. Even if they are getting more money now, that's fine, but there has to be some indication that the voters are not just simply approving going from nothing to something. And I go into, also, I know the city takes issue with my challenging the use of the word guaranteed annual rent. Again, when you take a look at the resolution approving the proposed lease, nowhere does it make reference to guaranteed annual rent. The language actually being employed is base rent, annual base rent, not guaranteed. And the city's response seems to suggest, well, so what? Guaranteed can have two different meanings. Well, then you wanna, the Florida Supreme Court cases are very clear. False, misleading, or confusing language. If the ballot projects confusion, or if the ballot will result in confusion to the voter, such that they don't really understand what they're being asked to vote on, and here, they're not only not, even the city's own memorandum, it seems to admit that, gee, this may be a little confusing, because they offer a different definition. Lastly, the city also, through, I guess, Mr. Torres' affidavit I just saw a few minutes ago, they seem to concede that this proposed lease does exactly what I described in the motion. Namely, there is a provision that will be given as soon as Grove Bay gets the lease approved, if it's approved by the voters. Grove Bay not only gets the ability to go forward and construct what they're going to construct, but they will have a contractual right somewhere down the road to go to the city commission and say to the city commission, they now allow gambling in the city. We want to use this land for that purpose. And that purpose is contemplated in the lease, because if you take a look at section, I think it's section 2-7 of the proposed lease, it says, big bold letters initially, prohibited gambling. But when you actually read the provision, it's one of those, this is prohibited, but then after that you say, notwithstanding anything in the foregoing, and then they tell you what really is happening here. Now this is, again, nowhere is there any mention of gambling. Nowhere is there any mention that this property can be used in the future. And now we're talking about a potential term of 80 years, that this property can be used for a purpose that does not comply with the existing comprehensive plan, which itself is prohibited by section 3F triple I think it's subsection capital C.
All right, I need you to wrap it up so I can hear from the county and then the other parties, and then I'll allow you to reply.
Your Honor, I believe we've been very straightforward in our presentation of the motion for emergency injunction. We're not asking, and we're not suggesting that the county need to go into any expense or redo ballots. In fact, I brought with me, and I will provide the court with a copy of the case out of the 3rd District in 2007, and it's entitled, it's City of Hialeah versus Delgado. And in that particular case, the court entered a temporary injunction to prevent an issue going forward, but also included, but more particularly, ordered that the ballots not be counted and that the ballots not be certified until after the tribal court and the appellate court could in fact determine the legal issues.
I'm familiar with that.
And what I'm suggesting, that it's a red herring that the county is raising, that there's going to be all this particular expense. There are means and an ability to control this, but if the court allows this election to go forward, and if the court allows the ballots to be counted and certified, then under the Florida Constitution, I'm not sure we're going to be able to undo it, because they will have a contractual right, and there's a prohibition against impairing existing contracts. Thank you.
Council, go to county.
If you walk out this courthouse today and walk over to the Stephen P. Clark Center, you can join the over 70,000 people who have already voted in this election, early voting or by absentee. The case law we cited in our memorandum, and by the way, there wasn't 2 cases, there were cases, at least over 10 cases. You know, Hooser from the Florida Supreme Court, you've got Wexler from the Westerman from the U.S. Supreme Court. All of them stand for the very simple proposition that there is no, in election cases, there is no constitutional right to procrastinate. There's no right to sit on your rights, to act as if nothing happened, and to wait to the last minute. And that's exactly what's happened in this case. And you cannot create your own emergency by waiting until the 11th hour and then filing an election case. Beyond the fact that it creates confusion in the election, beyond the fact that it has a potential, and I know plaintiff is now backing away from the request, but the request is to enjoin the election. And that is simply something you cannot do in the middle of an election for whether or not this is a questionable or whether or not this is a valid point, the county is disinterested in that. We do not speak to the merits of this case, we leave that between the parties. But the issue is, even if it was the most meritorious claim, at this point, it is too late to change anything. Whether or not this court wants to, at the end of this election, decide whether or not the ballot question authorizes the entrance into this contract is a matter between those two parties, not the supervisor. But the issue for the supervisor is whether or not the election can continue today. And we would urge this court not to allow a late filed complaint just because, like an ostrich sticking your head in the sand, we're ignorant to everything that's going on and to go forward. And the one thing I want to say about all these late found reasons as to why plaintiff did not raise this earlier, everything you've heard from plaintiff counsel, if there are arguments as to the merits of this case, all could have been seen in the July 25th resolution that adopted that ballot question. None of them have anything to do with anything else she said. She said she was waiting until the ballot question was final. That's just ridiculous on its face. The resolution calling the question for the election was on July 25th, 96 days before she filed her motion, 100 days ago. The election's on Tuesday. You cannot stop an election merely because she decided to wait till the last minute. And if you do so, you've effectively denied the supervisor, the city, and now the intervener with any meaningful right to appellate review of any decision you make today. The last thing I want to say, again, not on the merits, is the injunctive standard. The injunctive relief standard says you have to show how not only there is no other avenue for your claims to be redressed, but also how your harm outweighs the harm to the general public. If you look at the affidavit attached to my response, Supervisor Townsley tells you about the expense and the trouble this will cause in the election. You've heard nothing from them about what the harm to the public is, or how she will be irreparably injured.
Irreparable harm.
Right, the irreparable injury, the irreparable harm from allowing this election to continue and allowing the results to be published. Once you hear that, if they want to proceed with the case, if they think they've got a claim after that, they can go forward. And by the way, Your Honor, if this fails at the ballot box, we're done. There's nothing else for the parties to argue about. So I would just urge you for judicial conservatives to be conservative in your judicial rulings, but also I would urge you to think about what you're going to do, not only in this referendum question, but every other question. If you issue an order requiring the supervisor to change something on the ballot, I urge you to deny the motion.
I'm only dealing with this case. I don't think about future cases.
Well, but the issue...
Each case, facts as they're presented.
Of course, Your Honor, and I don't mean to imply that, but what I do mean to imply is that if you order the supervisor to change a ballot, it's every other question on the
You're
ballot.
thinking about precedent, but every trial court does what he or she deems appropriate based on the facts as they're presented.
Your Honor, I apologize, I'm not talking about precedent. I didn't make myself clear. What I'm saying is you cannot change the entire one question on a ballot without affecting every other question on the same ballot.
The same, okay.
By acting today, you affect everybody else.
Now I understand. I didn't hear from the city.
Okay, Your Honor, thank you. First of all, Your Honor, I'm going to be addressing the merits. Did you receive the city's e-courtesy filing last night?
I did.
Okay, good, okay. Now, I'd like to wipe the blackboard clean and start fresh. First of all, I'd like to explain to you what this case is about and what the case is not about. This case is solely concerning whether the title and summary of a referendum question is legally sufficient. That's it. We're not talking about amending the city charter. We are not talking about whether a city commission resolution is sufficient or not. We're talking about ballot language. Now, I'd like to run you through the facts. It'll take me a minute. We're talking here about 7 acres of city-owned property in Coconut Grove. They have 5 addresses, and I list them in our motion. To list just the addresses of these properties that are concerned takes up 35 words. The ballot is limited to a maximum of 75 words. Of these 7 acres, 0.94 of them are submerged lands. The plaintiff erroneously asserts as a fact that this property, the submerged land, is owned by the state of Florida. It is not. That's erroneous. They misunderstood. We've attached the deed for you. We own the property that we're leasing, or proposing to lease. On January 11th, 2013, the city began a procurement process through an RFP to solicit proposers to determine which one was the best. We went through the process. We had a selection committee. Every other developer except the one that was awarded dropped out. That person was selected. The city commission determined that this was a sufficient proposal and in the best interest of the city of Miami. It obtained appraisals, and at the end of the day, they determined they would put this out for referendum. And they did that only after fully negotiating the terms of the lease, which has now been signed and is on the city's website for the world to see. All of the terms, the consideration to be paid for the city, the exact address of the property, all the extras that we're going to get, everything is in that lease and available to the public. Now, the actual ballot title and summary, we quoted for you in our motion. And now, 96 days after we've made this award and asked for the county to put the question on the ballot, Ms. Solares files this lawsuit 5 days before the election. Okay, the first thing that you should be aware of is the test. What is the test? What do you have to determine to decide if this particular ballot is legally sufficient? It's very clear. The test is put out for you in Florida Statute 101.161. And the test is, it has to be clear and unambiguous language that sets forth the chief purpose of the measure. That's very simple. And the Florida Supreme Court has told us that the ballot has to be fair and advise the voter sufficiently to enable him intelligently to cast his ballot. Now, just by looking at the clear language of the title and the summary, the title says, "Proposed Lease of City-Owned Waterfront and Submerged Lands in Coconut Grove." And then the summary gives more detail in 73 words. I submit to you, just by reading that language, Your Honor, that is clear and unequivocal that we are seeking the voters to approve a lease. What we have included in the summary are the pertinent terms of the lease. The size of the property, 7 acres. The location of the property, it's waterfront and submerged lands in Coconut Grove. The identity of the proposed lessee, which is Grove Bay. The compensation to be paid by the city, a minimum of $1.4 million guaranteed annual rent. And we're going to talk about the word guaranteed later on. The express purpose of the lease, to redevelop a marina and baywalk and construct a restaurant. And the additional consideration that Grove Bay is going to provide the city. In other words, a financial contribution of $17.5 million in private investment. And the term of the lease, 50 years with 2 renewal options. Now, the first argument that Ms. Solares makes is, well, we can't tell where this property is, because all you say is waterfront and submerged property in Coconut Grove. And she says that's hiding the ball, and you're misleading the voters because you're not telling them exactly where it is. Well, this isn't the type of case where we have multiple 7-acre parcels of waterfront and submerged lands in Coconut Grove that the city owns and has a marina and baywalk on. We only have one of those. And this has been in the papers many, many times. It has been the subject of numerous public hearings. It's on the internet for everyone to see. There is no question about what property is involved here. The next thing that my opponent, and I'd like to take this opportunity to distinguish the recent decision of the 3rd DCA in Miami Beach Decide versus City of Miami Beach. In that case, which was just decided with an opinion by Judge Logue, just a month ago. That concerned the redevelopment of the convention center out in Miami Beach. And they also put a question on this same ballot asking their voters to approve that development. But the distinguishing feature there, and why the 3rd DCA struck that question down, was they had never negotiated a lease with a developer. They just had a letter of intent with no specifics of any kind. No, what the compensation was, what the property was, nothing. Square foot, nothing they had in it. And then the 3rd DCA said, well, how are the voters supposed to know what they're voting on if you don't even have those minimum terms? We have all those terms. We have a signed lease waiting, that's already executed, just waiting for voter approval to say yes or no. So that's a huge distinguishing feature. What is the second issue that Ms. Solares had? Well, Ms. Solares says that 29B of the city charter, and mind you, there are 2 sections of the city charter that are in play here. One is 29B, which concerns anytime the city leases property, it has to go through a certain process. And section 3F, 3 little i's of the city charter, which talks about what you do when you have to lease waterfront property. So we've got 2 city code charters that we have to comply with in this matter. 29B has a requirement that unless you receive 3 bids, which we did not, we only received 2, you have to go for referendum approval. Well, that's what we're doing. We're going to referendum approval. There is no need. Ms. Solares says, well, you have to disclose to the public in your summary that you didn't get 3 bids, and that's the reason why you're going to referendum. Why? There's no need to do that. The charter says if you don't get 3 bids, you go to referendum. We're going to referendum. We've complied with our charter. Next, she argues that in section 3F, 3 little i's, B of our city charter, we have to have a fair return come to the city, or else you have to go to referendum. We got 2 independent appraisals, and we complied with the charter. And the fact that Ms. Solares alleges otherwise is immaterial. We have complied with our charter, and we put an affidavit before the court saying that our facts are correct. The next thing that Ms. Solares argues is that under 3F, 3 little i's, C of the city charter, we can't do something if the comprehensive plan doesn't allow it. And she's talking about gambling. Well, our charter says if you're going to enter into a lease where the comprehensive plan is not complied with, before you enter into that lease, you have to go to referendum. That's what we're doing. We're complying with our charter. We don't need to put all that into our ballot summary for the voters to adequately vote on this. And indeed, gambling is illegal at the moment in Florida. Who knows if it will ever come to pass? If it does come to pass, then it'll go to the city commission to decide whether gambling should be allowed, and we'll probably readjust the rent. But in any event, gambling's not allowed at the moment. We're not doing anything that's contrary to the comp plan. But if it does happen, we're complying with the charter by going to referendum. Next, she says, well, under the city charter 3F, 3 little i's, E, if you have a proposed lease of waterfront property that exceeds a term of 5 years, you can't enter into that unless you go to referendum. Again, this is a 50-year lease with 2 extensions, and it is a whole lot longer than 5 years, so we're going to referendum. There is no need for us to put that in the ballot summary. All we have to do is go to referendum. That's what our charter tells us to do. Now, in the next category of items that Ms. Solares faults us with, is she says that we are being affirmatively misleading in two respects. First, she says that our ballot summary says that as compensation to the city, we're going to receive a guaranteed rent. And she says that that's false. There's no one who's personally guaranteeing that rent. So therefore, you have affirmatively misled the voters. Well, we submit to you, Your Honor, that there are multiple meanings in common usage of the word guarantee. And I'd like to quote to you the Black's Law Dictionary definition of guaranteed annual wage. And it provides that it's a provision in a labor agreement in which an employer agrees to pay an employee a certain basic sum of money each year, even though the employee has an hourly or weekly salary arrangement. That is the same usage that we're using that word in. And the court can take judicial notice of the dictionary and determine that people, the voters, should be able to reasonably understand that. Next, her last argument is that we have affirmatively misled the voters because we don't own our submerged lands. That is just a false argument that no one properly investigated before making that assertion in this court. We own that land, and we have an affidavit and the deed that was attached to our motion. I've covered everything that she's attacked about our ballot summary. It is clear that we are telling the voters exactly what the chief purpose is of this referendum title and summary. We've done it in clear and unequivocal language that no voter should misunderstand, and there is no merit whatsoever to the arguments that this citizen is making to challenge us. Therefore, we would urge you to deny this motion. Thank you.
Thank you, Your Honor. Your Honor, the bottom line, this is a motion for an injunction. The plaintiff fails to meet the four elements of injunctive relief. First of all, she fails to state how she has irreparable harm, especially in light of the fact that, as Mr. Rosenthal said on behalf of Supervisor Townsley, the ballot language was set July 25th. The ballot itself was printed September 21st. So at that point, everything was locked. On September 21st, when qualifying ended in the city of Miami, everything was turned over to the supervisor, and everyone knew what was going to be on the ballot in each and every municipality in Miami-Dade County, September 21st. And nothing was done until last week. If there is irreparable harm, if she is really suffering irreparable harm, why didn't she file it before? I think the timeliness factor of this is evidence in and of itself that she fails to meet the first element of injunctive relief, because if she would have suffered irreparable harm, she would have filed this at least on September 21st. Second, she fails to state why there's no other remedy at law. She says that once the vote happens, my client, Grove Bay, automatically has a contract right. Of course, they have a contract right. It doesn't mean that a court of this, of quality jurisdiction is not going to find that the contract may be void or that there's other problems. She still can get what she wants without this injunction. The most important thing here is she has very little chance of success on the merits. This case is first and foremost based on 101.161, which means that the public and the voters have to know exactly what the ramifications are of what they are voting for. If you look at the city of Riviera Beach case, Riviera Beach versus Riviera Citizens Task Force, this is a very key case in this argument. What does it tell you? It says courts are reluctant to enjoin elections. Why? Because you're going to disenfranchise voters, you're going to disenfranchise the electorate. An election can only be canceled in a very extreme circumstance. And 101.161 says the disenfranchisement of the voters by such a clearly misleading ballot question has to be so great that your only chance is to do this. The reason the lease referendum was taken off the ballot in the Let Miami Beach Decide case was the public could not be asked to vote to approve a lease when a lease did not exist. That was a complete lie to the voters in that case. In this case, this is very simple. It's not a constitutional amendment, it's not a charter amendment, it's an approval of a lease. What does the ballot language say? It says what the main terms of the lease are. any voter can simply go on to Legistar, the City of Miami website, and look at the entire lease. So all the requirements that were set out by Askew versus Firestone, saying that voters have a right to know all the ramifications, every single voter in the City of Miami has the ability to go on to that website and look at the lease and be informed as to what the ramifications are. Which brings us to an interesting point, because the plaintiff is looking at red herrings. They're trying to say that because there may be certain procedural problems with the way this lease got on the ballot, that automatically creates a violation of 101.161. It doesn't, because the voters can see past that. But any voter that goes on and looks at Legistar and looks at this lease will see that Ms. Solares is completely wrong on the issue of gambling that she's brought up. It specifically says in the lease, gambling is prohibited on this property. This has been a red herring that the plaintiff has brought up in order to create hyperbole among the public and create this sense of emergency as part of an argument that shouldn't be there. This is very simple. She is asking for an injunction to say that the ballot question is deficient. She has not proven her elements of 101.161. She has not brought up any voter to come and testify that they are confused. In fact, the only person we have heard from through her attorney is Ms. Solares, and Ms. Solares seems to know everything that is in here. So the only testimony before Your Honor today is that the one voter who is before you knows everything about this lease and can make an informed decision. That in and of itself proves that it's not a violation of 101.161. But without a likelihood of success on the merits, without meeting the burden of how they're going to be irreparably harmed by you enjoining this election, there is no way to disenfranchise the voters of the City of Miami and enjoin this election at this time.
Ms. Caroline, reason for action.
Yes, Your Honor. First, Your Honor, I believe counsel for the city is mistaken, because I'm not backing up anything in the motion with regard to this, the referendum. Our motion specifically is entitled, Verified Emergency Motion to Enjoin the Referendum Special Election Ballot Question, to enjoin counting the ballots, and to enjoin certifying the ballot results. And therefore, I recognize the ballots have been printed. I have presented both in the complaint for declaratory relief and more specifically in the verified emergency motion that we recognize this, and therefore the court has available to it the options to enjoin counting the ballots and the option to enjoin certifying the ballot results. Those, I believe, are the most appropriate under the circumstances, and there is not going to be any harm to the voters. The voters can still vote, but what I'm suggesting to the court is the court should not, until the court hears the entire case, should not be allowing these ballots to be counted, to be certified, because then we will have a contractual problem. And with regard to this injury issue that we're talking about, this is an injury to the citizens of the city of Miami. This is not something that an individual elector has to come in and show special injury. This is not a Rickover type case. The standing here is clearly established and recognized. Now, I won't delay much. I would like, however, to suggest that the city is trying to change the focus here by trying to compare this situation, this case, to the city of Miami Beach. In the city of Miami Beach, they were talking about, you approve this measure. There was no provision in the charter over there that limited, and more particularly, specifically states that the city officials do not have authority to enter into this lease. And so the issue in this case is not, do we approve this lease that we have authority for? The issue in this case is, will you give us the authority that we don't have? And for that purpose, there has to be an explanation of why we don't have it, and that's why I focus strictly on the charter language, because if they cannot satisfy that charter language, and if there is confusion being presented to the voters, then this should not be going to the voters, and in fact it should be stricken. With regard to one other point here, Your Honor, council cited, Mr. Planis cited the Riviera case, that did not involve, again, a situation where voters are being asked to give the city officials authority for something that they didn't have authority of. It was an entirely different type of issue being presented to the voters. So that case is not applicable at all. The cases that are applicable are the ones that I cited to, the Askew case, the Harris case, and in fact the term limit case, which says if you're trying to get something allowed, whether it be a formal amendment to the charter, and I stand with my same assertion that they are actually in the resolution, have asked, and they're attempting to proceed as if this is a charter amendment. So they recognize they don't have authority here. But so if you're going to tell the voters, give us authority, then you need to explain to the voters why they should do something the charter already prohibits. And that's why this case falls within the Askew case, it falls within the Armstrong case, it falls within the, I think it's the NAACP case that came out about a year and a half ago. You cannot just look at this as blind as this, as if that we're just asking for approval of a lease. They are asking for the voters to give them authority that they don't have. Thank you very much.
All right, the court has reviewed the plaintiff's verified notice of motion to join the referendum, special election ballot question, to join counting ballots and to join certifying the ballot results. I've also had an opportunity to review the responses following opposition by the city of Miami, as well as Miami-Dade County, that being Penelope Townsley, and also the memorandum in opposition filed by Rose Bay Investor. There's a venture, I'm sure you guys. I've listened to your arguments here today as well, and I reviewed the exhibits that have been referenced in your written submissions. I've also taken specific note of the ballot, proposed ballot question that has been submitted by the plaintiff to the court, here exhibit number 13. And more specifically, I've reviewed the case law that has been referenced by all of you, and most notably the elements for the imposition of an injunction. As we know, seeking injunctive relief is an extraordinary measure, and the court must be most careful in deciding on and actually imposing such relief. In reviewing the elements for an injunctive relief, at this time, the court is going to deny the plaintiff's motion, primarily because it has failed, or she has failed, to prove the necessary elements for the imposition of an injunction. There's been no showing of a likelihood of irreparable harm. There's been no showing of the unavailability of an adequate remedy at law. And based on my review of the ballot question as well, I find that there is not a substantial likelihood of success in the merits. The injunctive relief will not disturb the public interest here. So for all those reasons, the request is denied. That is my finding and my view. Thank you both. Have a great day.
Your Honor, may I make a request that the court order, and I'll pay for it, the transcript to be the court's ruling, because I respectfully will be filing an emergency motion to the 3rd District and seeking a stay, and I need to have a written ruling, and I know you're very busy, and since you've articulated your reasonings, could we use the transcript as essentially the order, if that's acceptable?